maintain other evidence that may not be exculpatory to a defense. That has some bearing on this issue. Here we have, there's an April 23rd Golden interview. That copy apparently was provided. There's an August 21st Golden interview. The Sheriff's Department had equipment to report on that date, but they turned it on and thought it was initiated to make a recording. They saved to a DVR and then put on a disc. But the DVR is no longer in that room, disposed of. The whereabouts were unknown. They asked the lieutenant of administration whether there was a tape or not. And the evidence custodian was unable to locate it, and the person Golden is available to testify. So there is exculpatory evidence in that matter, I believe, because Golden testified that Mr. Barker had no knowledge of this. In a general sense, that's the general content of the interview. So that would be potentially exculpatory, but it's not. It doesn't matter here if in fact Golden is available to testify, and I believe that person is available and can be subpoenaed and was listed as a witness here. And then there's a third one, which is Mr. Barker's interview, that he indicated he didn't want to speak to deputies, which doesn't contain any incriminatory evidence or exculpatory evidence. You simply exercise your right not to talk to deputies. So with respect to those items and the loss of some of that, where I believe in one instance there was a cell phone used, which was old technology and didn't work, which was an error. But again, I'm satisfied that there isn't any violation of Mr. Barker's discovery rights based upon the fact that the evidence that may have been lost isn't exculpatory, and if it was exculpatory, the person who was the maker of the statement saying Mr. Barker wasn't involved is the person who's available in person to be subpoenaed, and if that becomes an issue, we can deal with that in the course of trial. So I'm satisfied, and I will indicate that based on my understanding of the motion as written, I think I've addressed all the grounds, but in the event I haven't, I will order that the motion be denied on the basis of my oral statement here and decision, and also that it be denied on any other grounds that may not have been addressed by the court, because it's pretty broad on Mr. Barker's part, the way he's written it, and I don't want to leave any issues unresolved. So in its entirety, then Mr. Barker's motion to dismiss at this point is denied. Okay?
Excuse me, you didn't cover the part where he said he typed in the DA signature. You didn't cover that part.
Again, that's an electronic process that, again, is allowed by law with respect to telephone search warrants. All right?
Yeah.
So going on from there then, looking forward to getting us back on track here to get this case resolved by trial, we need to find a trial date. And before we have a trial date, we're going to set another date, which would be a date for a pre-trial, final pre-trial. Two things we're going to do at that final pre-trial for sure. One is I've already mentioned, and that is I would like to have the parties submit to the court in writing their voir dire questions, the questions they would like to ask the jurors about their qualifications to serve, all right? And then we'll discuss those at the next hearing, and I'll decide whether or not I'll allow you to read them to the jurors and ask them yourself, or whether I'll do it, okay? But first, let's start by writing out questions you want to ask the jurors about their qualifications to serve. The voir dire process is very limited in its purpose. It's to ask jurors about their qualifications to serve on this jury. It's not an opportunity to ask them questions about the facts of the case, about other things of that nature. And I don't envy you, Mr. Barker, having to do this on your own without an attorney. But because of that, I think it would be helpful to the court and perhaps to you to have you write out the questions. I might be able to help you formulate them in a more succinct and direct way to get at what you're asking, okay? So we'll have that, and then I'm going to ask the state to also prepare a suggested list of jury instructions. And I'm not going to have you do that, Mr. Barker. You can look at the state's jury instructions, and then we'll let you respond to them or ask for additional instructions. The jury instructions used in Wisconsin are what are called standard jury instructions. They're available online through books that contain jury instructions that apply, and almost always, in criminal cases in particular, there are standard jury instructions that are already in existence that are used to instruct the jury about their duty and so on, and about the law regarding the charges that are brought against you. I remind you that at trial, we don't try legal issues. That's what we've been doing here. It's the court's job to decide legal issues. The jury only decides issues of fact. So the jury will be asked based upon the instructions they're given and the elements of the offenses that you're charged with that they're told. They'll be asked to decide based on those elements whether you're guilty or not guilty based upon the instructions we give them about the burden of proof and so on. So you have to think about that in a different way, because all these things we've been talking about now are legal issues, and all those things we've talked about go out the window when we get in front of the jury, okay?
So jury ain't based on law?
No, it's not based on the law, it's based on the facts. They're going to be asked whether or not you were a conspirator in this theft of product from the company, the Cree company, okay? That's what they'll be asked. And whether, I think there's a marijuana possession charge as well. They'll be asked whether or not you possess marijuana, and we'll be instructing them about the elements of the offense. So, so we're going to now pick a date for jury trial, and then a date before that for a pre-trial, all right?
I would like to address something as far as for subpoenas.
Sure.
On the criminal complaint, I tried to subpoena the alleged person who swore to the criminal complaint. It says that it's Brian Van Zyk, but the signature is not his signature. It's Deputy K. The payroll number is 6518. The processor went to the sheriff department to subpoena the deputy, match the name with the payroll number, and Lieutenant Sean Barker says, I do hereby certify that there is no employee with the Racine County Sheriff Department with payroll number 6518. So I looked in all the discovery and tried to compare the names.
Probably have to go to the DA's office, Mr. Riegenfeld, and find out. I don't know how they do it now. I'll just tell you how they did it when I was DA and when I was judge. When all complaints are drafted in the DA's office, they have a representative from either the sheriff's department on a daily basis or the police department on a daily basis look at the papers and then sign the complaints. So it could be that person who's generally referred to as the liaison officer to the DA's office, or it could be whoever was on duty that day that had to carry the papers, whether it's is that a payroll number that matches the system of the sheriff's department, or could it be a police officer?
No, it says Deputy K, and I don't know what the last name is.
Could be detective, DET?
No, it's DEP K dot, I think it's F6518. And also the complaint, like inside the criminal complaint, it states that at the beginning of it says that Brian Van Zyk is the complainant. But right here, it says Deputy K 6518 is the complainant. And also, what?
Do you know who that is by chance? I don't want you to speculate, but.
I would just be speculating. I think I know who it is.
All right.
Who usually works over at the courthouse. I'm not sure.
Okay.
He swore to the complaint?
He wants to make certain before you may have to, we'll ask you, Mr. Wiedenfeld, to find out who that person is, and then maybe with a short letter to Mr. Barker and the court file, tell him who that is, okay? So we can have that name, all right?
Yeah, I need to subpoena whoever that person is that allegedly swore to the complaint.
Okay.
And also whoever this DA signature is that, because this DA signature is supposed to be Richard Trippetti, but it's not consistent with his signature. I have like 5, 6 documents signed by him, but it's not, his signature looks nothing like that. So
Okay, well, we'll ask Mr., I'll find those two things out for you and to let the court and you know. Again, I'll just explain to you, a jury trial would involve the facts of the case, not legal issues, and whether or not someone validly signed a complaint is a legal issue, okay?
No, the issue is, this person is the complainant is supposed to be a witness of me committing a crime, so I would like to cross-examine him in regards of me, you, he.
Sure, and the way it's done in every case,
Huh?
well, the way it's done in every case is a police officer, whether it's probably I'm the investigator involved in the case, will read reports, and then they will have that person sign the complaint as a complainant. It may not be a person even involved with the crime, okay? So it could be anyone who signs it, all right?
Objection, that is not what the law states.
Okay, well, we can argue about that if you want to file a motion, but we're not talking about that today, and that's a legal issue, not an issue for the jury, just so you understand,
Yeah, that's
okay?
why I'm trying to bring it up in court right now.
Okay,
In
well-
court of law.
Okay.
Let me ask you this, can I ask you one question with regard to, so you're stating that anyone, random person could swear that I committed a crime and I get binded over trial? This warrant, this criminal complaint states specifically, in the statute states that the officer must swear to a complaint. But, I mean, that's a deep issue. I just need to know exactly who this person is so I can subpoena.
Okay, well, again, it may relate to a legal issue, not something for the jury, but we'll go on from there. Looking at possible dates for a jury in, I can't do that week, but how about August 6th? How about August 13th through the 17th?
Can't see that.